filed in support of the motion, wherein I adopted and argued the 3 jurisdictional issues submitted to your Lordship for your determination. There was also a further and better affidavit and my reply on points of law filed in answer to the respondent's counter affidavit and written address. My Lord, I respectfully urge your Lordship to deem all these processes as argued and to grant the reliefs exactly as set out on the motion paper. And in a brief overview of what is contained in my motion, my Lord, my contention is very simple. That ab initio, this court lacks jurisdiction to try me, that this very court is a material defiance of an appellate court judgment, the Supreme Court, with specific regards to count 7, which does not exist in the laws of this very country, and which the Supreme Court mandated this very court to amend. That hasn't happened. The presence of count 7 on this charge sheet, my Lord, nullifies this entire proceedings completely and totally, because count 7, my Lord, does not exist in the laws of this very country. When I reply on points of law, I will make specific references to the ratio that came down from the Supreme Court, where my Lord Lawal Garba explicitly stated that count 7 should be changed. That hasn't been done, my Lord, and this court is in contempt of the Supreme Court binding order. My Lord, the entire argument of the respondent, I'm sorry to say, collapses on just one single point, not many, just one. The Supreme Court's pronouncement on the statute of the written law is immovable. It is enshrined in the Constitution of this very country unless a law is written. Unless it is written, defining that very offense, no trial, no conviction can ever take place. And it is my submission, my Lord, that this very morning, as we stand in this very hallowed chamber, count 7 does not exist. And not only the repealed laws that will come later. Count 7, my Lord, destroys this entire trial, because Supreme Court gave an explicit order which wasn't adhered to.
The consultant, you have to go to the defendant to tell him the procedure here. We have the practice of front-loading. I think he has filed his written addresses in support of all this motion. So it's not to repeat what he has stated in his written addresses, but to state the relief is sit for, and just use a minute each in respect of each motion for operation.
Okay. But it wasn't. Yes. I am most grateful, my Lord. I am, without flogging a dead horse, I am asking this very honorable court, my Lord, to please kindly grant my prayers as contained in the motion for reference to the appeal court, and may I also identify the affidavit in support. It is only a 6-paragraph affidavit, my Lord, deposed to by my younger brother, Prince Emmanuel Kanu, also dated the 12th day of November 2025. There is an accompanying affidavit of urgency, which was deposed to by my humble self, also filed on the 12th day of November 2025, and also a written address. My Lord, in support of the motion on notice, praying for the orders I had earlier outlined, that too was dated on the 12th day of November, my Lord, may I most graciously ask my Lord to grant these prayers. Thank you very much.
What about the other two motions?
I should move them at the same time?
Yes.
Thank you.
I've made an order consolidating the hearing of the three motions.
Okay. The next one, my Lord, is an application, a notice of my commitment to file a final written address, which was dated the 11th day of November and filed on the same 11th day of November. It is accompanied, my Lord, by grounds upon which this very application is predicated, and the grounds are 4 in number, my Lord, and I went on to elucidate the body of objection and then the constitutional foundation and jurisdictional limits of this very court.
You will have the grounds stated?
Yes, my Lord, you may. Ground number 1, my Lord, states here, the defendant, having called evidence through cross-examination of all the complainant's witnesses, has given evidence and entitled to the summation of those points through a final written address. So I have actually entered my defense, my Lord. What I did not do is to call a witness, because the evidence tendered by the prosecution were surgically demolished. The right to ground 2, my Lord, the right to final address is a fundamental constitutional right integral to fair hearing under Section 36, Sub 1 of the 1999 Constitution, and no court has jurisdiction to unilaterally order its waiver without the express, informed, and voluntary consent of the right holder, which is myself. The third ground, any order directing or implying a waiver of final address constitutes a breach of fair hearing, my Lord, which goes to the root of the court's jurisdiction and renders the entire proceedings a nullity. The court, ground number 4, the court lacks jurisdiction to extinguish or dispense with mandatory procedural stage of criminal adjudication, such as a final written address, as this would amount to an unlawful assumption of power beyond the limits prescribed by the Constitution and extant laws. And ground number 4, for reference purposes, my Lord, Section 36(1) of the 1999 Constitution, which the court has taken judicial notice of. Those are my grounds, my Lord, in respect of the notice seeking this court's discretion to allow me to file my final written address. Having entered my defense, I move that this very notice be adopted, my Lord, in its entirety. The third and the very last one is the issue of bail, my Lord, the issue of bail. This was dated the 17th day of November 2025 and filed on the 17th day of November 2025. It's a very simple one. It is a notice, my Lord, brought pursuant to sections 35(1), 35(4), and 36(12) of the Constitution of the Federal Republic of Nigeria, 1999, amended, sections 158, 162, and 165 of the Administration of Criminal Justice Act 2015, and under the inherent jurisdiction of this very noble court, I am praying, my Lord, for an order admitting me on bail, the defendant applicant to bail on liberal terms, pending the determination of the invalid charge presently before this court, an order, my Lord, declaring that the continued detention of the defendant applicant, my humble self, in the absence of a valid subsisting charge under a written law in force, is unconstitutional, null and void, my Lord, and for any other orders that my noble Lord may deem fit to make under the circumstance. This is supported by an affidavit of 9 paragraphs deposed to by Prince Emmanuel Kanu, and also by a written address which I urge my Lord to accept its adoption. Honorable Lord.
Yes. You moved the 3 applications?
I have, my Lord.
Thank you.
Thank you.
The prosecuting counsel, can you react to those 3 applications?
May please, Your Lordship. The prosecution filed reply to the first motion on the 14th of November 2025. We also filed a reply, a counter affidavit and a reply in respect of the first motion. For the second motion, we also filed a reply all on the 14th of November 2025. For the third one, for the further application for bail, we did not file any counter affidavit. So for the first one, sir, I respectfully adopt the counter affidavit of the prosecution and the written address. And we urge Your Lordship to dismiss the application because it's a regurgitation or repetition of the well-worn argument that the counts which the defendant pleaded to were unknown to law. It is for Your Lordship to determine that in other ones. But the one asking for stay of proceedings, my Lord, our argument is to the fact that the statute does not permit Your Lordship to grant any stay of proceedings or injunction. So we ask Your Lordship to dismiss it. And for the second, we also filed a written address dated 14/11. We adopt it with all respect, and we urge Your Lordship to dismiss the application as lacking in merit. For the last application, asking for the defendant to be admitted to bail on the same ground that, the counts to which he pleaded not guilty were unknown to law. Again, is a repetition of the old argument. It is for Lordship to determine whether the laws were valid, whether his plea was valid, and whether he is answerable to the law when he committed the terrorism acts. The terrorism acts he committed was...
Please,
So we urge Your Lordship to dismiss the application. On the other ground is also to the fact that the applicant has another pending motion filed in March, in April 2025, asking for the same relief, bail. So the latter application with respect, is an abuse. In any event, none of them merits. We urge Your Lordship to dismiss it.
Please, let's save the time of the court.
We appeal Your Lordship to dismiss all the applications because they lack in merit and do not deserve any consideration at all. Thank you, my Lord.
Thank you, sir. Defendant, you have 1 or 2 words to say?
Most certainly, my Lord, and I'm most grateful. My point is a very simple one, my Lord. Very, very simple. my charge sheet, as presently constituted, does not reveal or disclose any written law in Nigeria as at this very morning.
Thank you.
It doesn't exist, my lord. And very finally, I think it is very, very important that I allude to what my lords...
Please, defendants, at this point, you won't go and make references. I just ask you to reply on point of law.
It is, my lord. I'm trying to explain exactly what the point of law is all about. We respect what you have just said.
Yes, let me hear the point of law.
My lord, I cite Eze v.
I'm coming. Consultants, you may guide him properly. Thank you. Let the consultant sit with his client. Or do we have all the consultants? Do they want to sit with their clients? Okay, let me see. Are you here? Mandela, you're here. Opara is okay. Where are the others? Ejiofor? Where are the others? Yes, you just have 2 minutes for this. Yes. Yes, up 2 minutes for this.
Thank you, my lord. I'm most grateful. Once again, I will start with the bail application that I made. Since he did not file any counter affidavit, my lord, he is in effect conceding. And I expect that this very application should be determined based on the affidavit that I filed.
You may sit down.
And on the issue of stay, my lord, once a matter borders on jurisdiction, stay can be granted. Once it is a jurisdictional matter, stay can be granted. What I'm asking for is for a referral, my lord, to the appeal court for the determination of these very key issues. And also, I reiterate that Abuja is not superior. It is not superior to the Constitution of this very country, and an established jurisprudence as determined by the Supreme Court that stays can be invoked insofar as the issue borders on jurisdiction. And my lord, this is very, very critical. Not minding anything we may have said before, or I may have said, the fact of the matter is that the very count 7 laid under Criminal Code Act Cap C45, my lord, is not Nigerian law. It doesn't exist. It just doesn't exist. Why should I be in detention over charges that don't even exist, my lord? It doesn't.
You are exceeding the 2 minutes.
Okay.
Just
yes, please. I ask my lord that I be granted bail on very favorable terms, given that a concurring judgment of the Supreme Court of Nigeria determined, my lord, and found that I did not jump bail. I never did. That was their finding. I did not jump bail. And that the revocation of my bail implied that.
It's okay.
Thank you, my lord.
Thank you.
I've said it.
You may sit down. I'm going to read extempore as the application and all before these courts. The defendant filed 3 applications after the matter was adjourned to today for judgment. The defendant filed a motion on the 17th day of November 2025, seeking for 2 reliefs. 1, an order admitting the defendant's applicant to bail on liberal terms pending the determination of the invalid charge presently before this honorable court. The second relief is for an order declaring that the continued detention of the defendant applicants in the absence of a valid subsisting charge under a written law in force is unconstitutional and void. The second application is the motion on notice dated and filed on the 12th day of November 2025, seeking for 2 reliefs. The first relief, as stated in this motion, is an order referring certain substantial constitutional questions arising in this trial to the Court of Appeal, pursuant to Section 295, Sub 2 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The second relief is an order staying further proceedings in the charge, pending the determination of the referred questions by this court to Court of Appeal. The third motion has to do with the notification to file written address. As defendant stated, he has put in his defense as his right to file written address should not be taken away from him. I've considered also the processes filed by the prosecution in reaction to some of the motions. In the application seeking to refer some questions to the Court of Appeal, the defendant submitted inter alia that the court cannot proceed to give judgment on a defective charge not founded on a written law, and that the court cannot rule on count 7 of the charge, contrary to the decision of the Supreme Court. I must say, most of the issues raised here in the application, save the application for bail, have been raised by the defendants severally in these courts. And these courts have made an order that all preliminary objections or issues shall be taken during the judgments. This court is bound by that order. However, the issue as regards to referral of questions to the Court of Appeal and the stay of proceedings the statutory law governing criminal procedure in Nigeria. 2 weeks. Administration of Criminal Justice Act 2015. By Section 306 of that Act, which provides that an application for stay of proceedings in respect of criminal matters before court shall not be entertained. These statutory provisions was initiated by the Court of Appeal in the case of Shuaibu versus Federal Republic of Nigeria. I must speak as to the essence, the reason for this statutory provision, that is Section 306 of Administration of Criminal Justice Act. The essence of this provision is to prevent inordinate delay through the filing of appeals while trial is going on. For this reason, the Section 306 of Administration of Criminal Justice Act having provided that such application shall not be entertained, these courts shall not entertain same. As regards to the application seeking for bail, we have different types of bail applications. Bail application can be bail pending trial or bail pending appeal. I've looked at the application for bail. This application before this court does not fall within those two classes of application for bail. In this matter, as also stated by the defendant, that he has put in his defense. Hearing has been concluded. And also, by the order of these courts, on the 27th day of October 2025, the court made an order that the defendant should next date put in his defense, or if he's not putting his defense, he should file address which shall be deemed to be final address. The defendant's portion to that filed motion and comprehensive address. It is based on this that I hold that issues are relieved is highly unmeritorious. Same is hereby dismissed. Like I said earlier, all other issues have been raised through that motion and comprehensive final address that was deemed as final address, and another motion filed thereafter. These courts, in the interest of justice, will not close its eyes to see. The court will determine all this issue in its judgments. I proceed, I deliver my judgment. Judgment, please.
My Lord, I have an objection. Final written address is a constitutionally mandated right which I must be granted. It is in the constitution of this very country that final written addresses, my Lord, must be granted. I have not waived it, my Lord, and I insist that I address this court on all these issues. My Lord, do not permit.
The defendant?
My Lord.
Consultant, can you tell your...
My Lord, I will not, please, let me finish.
Please.
It's my case.
I've gone...
It is my case, my Lord, let me finish. My Lord, this very court, a member of the FAN was here, my Lord. A member of the FAN said, at the end
which reads thus.
My Lord, I'm saying it clearly.
Defendant, defendant,
What is the permitting address? The Constitution. My permitting address.
defendant,
The permitting address. What is it?
can you listen to the court?
My Lord, please.
Can you listen to the court?
My Lord, I need to find my final written address. It's in the Constitution.
I appeal to you to comport yourself this temple of justice.
My Lord, you are best. You are best. This is not law. You are best. It's not law.
Please, I beg you to comport yourself.
My Lord, this is not law. Show me where it says you can waive my right to written address.
Beg you to
Show me.
comport yourself.
Show me where it says you can waive my right to final written address. And I put that.
You
Show me.
in the
My
name.
Lord, you are conducting the test for them. You are preparing the test for them. Let them show me the Constitution. Show me where it says you can waive my right to written address.
You have the right to appeal after my.
No, my Lord, this is your perversion of the court of justice. This is not law.
Can you
It is not law.
excuse me?
My Lord, I cannot excuse
Let him take
It's
out.
not possible. It is not possible, my Lord.
Take him.
You must show me where the Constitution says you have the right to waive my written address. You must show me.
Excuse him.
Show me. Show me where it says so. Show me. Show me where it says so.
Excuse him at.
Is that how you brought the camera? Is that how you brought them today?
Please,
You didn't bring it before, you brought it today?
please,
Show me where it says you can find me on the repeat law. Show me.
please get the microphone from him, please.
I said, show me. Show me.
Excuse me. Get the microphone from him.
No, leave it. Leave it. Leave it. I said, leave it. It's a court of law. I'm under trial. I'm under trial. I have to speak. I'm under trial and I have to speak. Listen to me. Listen to me, please. I'm under trial. I'm under trial.
Please use the
I'm
microphone.
under trial. And I must address the court. Wait. No, listen to me. Please. The judge must listen to me. No. Wait. Wait. I'm asking a very simple question. No. Wait. Please. This is Supreme Court. Wait, hold on. This Supreme Court here. Hold on a second. May I please your lordship? I said, hold on. May I please your lordship?
Please.
May I refer the lordship to section 266 of Abuja? It's not a court of law. What you're doing is not law.
Please.
You don't know the law.
Please.
Show me.
Please.
I said, show me. When you have the right to waive my right to final address. Show me. It's what the Constitution says. Show me.
Well, I will rise and come back.
You cannot show me.
Can you please
You cannot
take him
show me.
out?
Because no,
I will come back.
You can't show me.
I rise.
Wait, hold on.
I'll come back in 5 minutes.
Don't do that. Show me where it says you can waive my right. Show me the place I'm asking. Show me. Show me. Which law says you can try me an unwritten law? Show me. You cannot show me. You're a judge. You claim you're a judge. You don't know law. You don't know law. Nonsense. Where is the family written address? Where is it? Which law gave you the right to waive my family written address? Which law gave you the right? You think I'm trying to this is place I try with me. What's this one doing here? What are you 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 doing here? This is the idiot that attacked me. This is the fool that attacked me. That's the idiot that attacked me. That's the fool. I'm going don't talk. Don't talk me. I'm warning you, don't talk me. I'm warning you, don't talk me. Don't talk me. Don't touch me. I said, don't touch me. Don't. Smart people. You don't know law. Show me where it says you can waive my right to final address. Show me the law. Show me the law. I want to show me the law. You don't know law. They are demoting you. You're writing rubbish. Show me the law. Unaddressed affidavit. You say you waive it. Are you doing their job for them? Ndara. God will punish you now and forever. Any judgment, let it be on record. Any judgment given in this court is rubbish. Ask him, where is the law? Ask for what? Where is the law?
Let's go, please.
Where is the law?
Let's go.
Lawyers, judges, Yorubas, don't even know if we are at war with each other. I'm so disappointed that our Yorubas engage in this. It's good we say it. From the Chief Justice, from the Attorney General, from DSS, from lawyers, judges, they are all Yorubas. Finish what I was saying. No, let me stop.